In Australia, there's no automatic right for a criminal accused to be represented by a lawyer at public expense. Legal aid in Australia does exist, but it's quite restricted. In a case called the Crown and Dietrich, the High Court established the principle that if a judge considered that, having regard to the significance of the offences, a fair trial could not be conducted without the defendant having legal representation, and if the defendant was without legal representation due to no fault of their own, then their criminal proceedings could be stayed, either until representation was provided or permanently. Mr. Craig was accused of stealing a car and destroying it by setting it alight. The offences could potentially land him in prison for several years. He also had massive debts and was involved in family law proceedings for which he had other legal bills. He did receive a bequest of $20,000, which he used to pay down debts, but things got too much, and he broke bail and fled to Sydney. He was extradited back to South Australia. On the car stealing charges, he asked the court to apply the principles in Dietrich, and the judge agreed, staying the charges until legal representation was provided. Legal aid, however, refused to provide him with representation because he had not reported the bequest of $20,000 and he had broken bail. On that basis, the judge stayed the charges indefinitely and the Crown appealed that decision. One question in the High Court was whether there had been an error of law on the part of the judge at first instance, and if there was an error of law, what its effect was on the decision. The court found that there probably wasn't an error of law because the only real contention was about the relevant facts. But even if there was an error of law, it was an error that occurred in a court. They said that unlike an administrative error of law, an error of law in a court could simply be corrected by a higher court on appeal. The court said, regardless of whether it be viewed as a question of law or a mixed question of law and fact, however, its resolution lay within the primary authority of the trial judge. From this case, we learn that errors of law invalidate administrative decisions, but they do not invalidate judicial decisions.